You know that feeling, right? You sign on the dotted line and you just assume that piece of paper is a rock-solid, legally binding contract. But what if it wasn't? What if the contract itself had, like, a secret escape hatch? A few words that made the whole thing, well, unenforceable. Today, we're going to dive into a really fascinating legal case where a signed agreement was actually designed not to be a contract at all. So this leads us to the central question for this whole explainer. When is a signed business agreement not a legally binding contract? It sounds kind of like a riddle, right? But believe it or not, the answer comes from a real-life legal drama that went all the way to the UK's highest court. Okay, so our story begins with what seemed like a totally normal business relationship. You've got two successful companies, they've worked together before, they've got a great partnership going, and they decide, you know what, let's put this all down on paper. So let's meet the players involved. On one side, you have Rose and Frank Co., and they're the sole distributor in the US. And on the other side, you've got J.R. Crompton Bros, a British company that supplies carbon paper products. It's a classic setup, right? Totally mutually beneficial. One company makes the stuff, the other company sells it. And for years, their partnership was really successful. Everything was going great. Then, in 1913, they decided, hey, let's formalize this thing. So they signed a new document to govern their whole arrangement. But then things went south. The relationship started to break down because of unfulfilled orders, and this dispute, it escalated, and I mean really escalated, all the way to a lawsuit in the highest court. So what went wrong? How did the successful partnership just fall apart? Well, it all came down to a few very unusual words buried deep inside that 1913 agreement. And this is the heart of our story. We're talking about the honor clause. And right here, this is where a standard, boring business document turns into something else entirely. I mean, everything, the whole case, hinged on this one single passage. Just a few lines that lawyers and judges would pore over, because it held the key to everything. So get this. The document explicitly stated that this arrangement was, and I'm quoting here, not entered into as a formal or legal agreement. It was just a definite expression to which they each honorably pledged themselves. So they're basically saying this whole thing isn't for the courts. It's just an honorable pledge, a gentleman's agreement built on trust. They literally wrote, this is not a contract, inside their contract. Wild, right? Okay, so you've got this agreement and it's built completely on honor and trust. But what happens when that trust gets broken? Well, that pledge of friendly cooperation was about to be put to the ultimate test. And here's the conflict in a nutshell. The honorable pledge talked all about mutual loyalty and friendly cooperation, but the reality of the business dispute? J.R. Crompton just refused to supply some of the orders that Rose and Frank Co. placed. So from Rose and Frank's point of view, this was a total violation of their deal. So Rose and Frank Co., believing they had a totally legit, legally binding deal, did what any company would do in that situation. They sued. They took the whole thing to court, trying to get a judge to force J.R. Crompton to stick to the agreement and deliver the products. Now, this wasn't just any old court case. It escalated. And I mean, it went all the way up to the House of Lords, which at the time was the highest court in the UK. They were going to have the final word on what this so-called honorable pledge actually was. And the verdict? It was stunning. The court ruled that the 1913 arrangement was absolutely not a legally binding contract. Rose and Frank, they lost. That honor clause had worked exactly like it was supposed to. So why? Why wasn't it a contract? Well, it all comes down to a fundamental principle of contract law called intention to create legal relations. Basically, for a contract to be valid, both sides have to actually intend for it to be legally enforceable in court. And in this case, that honor clause was like a giant flashing neon sign that said, we do not intend for this to be legal. They had explicitly told the courts, stay out of our business. Okay, so I know what you might be thinking. That's a cool story from 100 years ago, but what does it have to do with me today? Well, the takeaways from this case are just as important now as they were back then. Actually, they're pretty critical for anyone. So let's break down the lessons from this whole honor clause thing. First, words have real, actual legal power. Just saying something isn't a legal agreement can be enough to make it true. Second, it's so important to state your intentions clearly. Because they were so clear, the court had to respect that. And that's a good reminder that, hey, not all agreements are legally binding contracts, even as they're written down and signed. And of course, the big one, the timeless advice. You have to always read the fine print. And that kind of leaves us with one last question for you to think about. What about the promises in your own life, both personal and professional? Which of those are based on law and which ones are based on honor? Like the one we just talked about, just relying on trust. You might be surprised when you really think about it.